Okay, so let's finish everything out for this lecture. Now that you have heard me talk a little bit about and read about theories of constitutional interpretation that sort of begin and end with the text of the Constitution and history, now we're left with this other family, the sort of everything else family. But one thing I should say, sort of at the outset, is um, if you've any of these theories on sort of this branch of the taxonomy, um, they still care about what is written in the text of the Constitution, and sometimes even they care about history. Where they differ is they think that the text itself and history can't get you all the way there. It's not that they don't matter, it's that they can only provide part of the answer. And the reason why adherents of these philosophies think that textualism and originalism can't get you all the way there is that they just don't provide a good enough a solution to ambiguity when words can mean many different things, but also social change. That we are interpreting a constitution in a very different reality in which it compared to when it was written. Now, none of these theories should be labeled a living constitution approach, even though you would think that that if the Constitution doesn't get amended, but it gets reinterpreted as society changes, well, that isn't the Constitution keeping pace, and therefore it's kind of alive and getting adapted. Not necessarily. The term living Constitution is more of a pejorative term put forward to sort of describe any progressive academics or progressive judges' constitutional philosophy. The theories of interpretation that we're about to go over are a little more concrete and grounded than just like, oh well, we can just adapt the Constitution however we want, make it live and grow however we want. So, within this family, you have a few theories around references to utility, usefulness, practicality, those sorts of things. That constitutes one genus. And then deference to the other branches of government is a sort of organizing principle for a few other theories of constitutional interpretation that I'm about to go over. So, references to utility. Again, this involve one way in which you could want to come up with a sort of like useful constitutional interpretation is through structuralism. Structuralism is a belief that you read a particular part of the Constitution in light of the broader purposes of the document, right? And so um, think of an analogy with like the structure of a human being, right? Like if you want to um, define what a finger is, you need to understand like the purposes that fingers and hands and even like entire arms, because fingers are such an important part of an arm, right? Like what goals are they supposed to accomplish? What is their purpose in helping us survive as a species, right? And so you can do the same thing with constitutions. You can take one small part of it and then take a step back and say, okay, what is our Constitution supposed to do, and so what role does this small part play in that broader those achieving those broader goals? Then there's something that's a little more sort of practically oriented than structuralism. Well, I don't know. I don't. I that's a bad description. I'll just the next. I'll just move on. The next theory is sociological jurisprudence. And this is a theory of interpretation that holds that judges should decide cases based on which outcome makes society better off, improves societal welfare. And oftentimes, in order to figure out which side of a legal case best advances societal welfare, they're going to look at scientific evidence. to help guide their decisions. So, what's an example of structuralism? Here's an extended quote from McCulloch versus Maryland, which is one of the cases we're going to read this semester. It's obviously a Maryland case, but the controversy actually took place in Baltimore, about a block from the power plant downtown. We'll get into that a little bit more in a couple of weeks. So this is the case where the issue was, does Congress have the power to establish a national bank? Because if you hit Control F in the and search through the Constitution, you will not find the word bank as something that the Constitution explicitly gives Congress the power to create. And then the other issue in this case, and that's what this quote is from, is even if Congress does have the power to create a bank, does the state of Maryland have the right to tax it? John Marshall, who wrote the majority opinion, the only opinion in McCulloch, he says no. He says, if we apply the principle for which the state of Maryland contends to the Constitution generally, we shall find it capable of arresting all measures of the federal government and prostrating it at the foot of the states. The American people have declared their Constitution and laws made in pursuance thereof to be supreme, but this principle would transfer supremacy, in fact, to the states. Okay, there's a lot going on here, so bear with me. The argument here is that if you allow a state government to tax an institution set up by the federal government, what you're basically doing is you're giving a state to set up a really, really onerous tax, right? A tax that is so high that the Bank of the United States can no longer turn a profit. And that's a problem because the bank was created by a nationwide vote in Congress. Now, I don't know whether Maryland's congressmen and senators voted in favor of the bank or not, but you know what? Enough members of Congress did vote for it. And so you essentially have the support of the nation behind establishing this bank, and yet why would it be okay to allow one state to effectively undo the bank by taxing it into obliteration, right? And so what Marshall is saying is, if you look, there's a part in the Constitution, it's called the Supremacy Clause, and it says that at the top of our legal food chain is the U.S. Constitution and all federal laws made in pursuance of the Constitution. In other words, most of the time the federal government is they're supposed to triumph over the states. But if you give states taxing power to undermine federal institutions and tax a federal government entity into the ground, you're basically saying, no, the federal government isn't at the top of the food chain. It's the states, and that doesn't make sense. Allowing a state to do this, a very concrete, particular thing, allowing that to do that is wrong because it undermines this broader goal. The broader goal, as outlined in the Supremacy Clause, is the federal government is supposed to trump the states and not the other way around. So that's structuralism. You would be undermining a broad purpose of the Constitution, which is national supremacy, by allowing a state government to tax a federal institution. Sociological jurisprudence. This quote also comes from an opinion that we will read later in this semester, Lochner versus New York. What you have in this case is a law limiting the number of hours that you can work in a bakery to 10 hours a day or 60 hours a week. And the challenge was raised about whether this was an arbitrary interference with both the right of bakery workers to work as many hours as they wanted, but the right of bakery owners as well to, come to an agreement with workers to have them work very, very long hours. And the majority opinion actually strikes this law down as a violation of economic freedom Justice Harlan writes this dissent, and he says, no, 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 I think this law should be upheld. Why? Because it protects workers' health. How do we know that this law protects workers' health? Let's consult the best science that we have available. Professor Hurt, which I think it's hilarious that he's writing about worker safety, and his name is Hurt. In his treatise on the diseases of the workers, has said, the labor of the bakers is among the hardest and most laborious imaginable, because it has to be performed under conditions injurious to the health of those engaged in it. And he's not wrong. It kind of sucked to work in a bakery at the beginning of the 1900s. Cramped, windowless rooms made it like really, really hot in the summer, really, really cold in the winter. It's poorly ventilated, so you're breathing in all the like flour dust and stuff like that. Harlan's take here was that this law wasn't meant to undermine people's economic freedoms to, make whatever economic decisions they want. This is an example of a government trying to promote public health, which is a legitimate thing to do to ensure that when people participate in the economy, they don't do so, while risking their lives. Okay, deference to the other branches. One theory of constitutional interpretation that falls under this heading is what's called judicial restraint. And it's based on the notion that every elected official, and I have listed Congress and the president, but actually like governors, city councilmen, even where you elect dog catchers, every elected official in this country takes the same oath of office to uphold, to preserve, protect, and defend the Constitution of the United States. And so, why does that matter? Well, it means that why should we think that judges are the only ones who care about obeying the Constitution when everyone, judges and elected officials, all took the same oath of office, right? And so if they're following their oath of office, a Congress should not pass an unconstitutional law. A president should not sign an unconstitutional bill that's been passed. He has an obligation to veto any bills that he considers to be unconstitutional, right? And so, if a bill has gotten through Congress and has been signed by the president, perhaps judges should be more hands-off because, it's not automatic. And we shouldn't assume that it's automatic that elected officials were trying to subvert the Constitution. So one approach to this, another approach to deference to the other branches is called pragmatism. This has to do with judges understanding that they are experts at some things like, how to protect individual rights and sort of more abstract philosophical things. But when it comes to like concrete problems, like how do you reduce the number of people who don't have health insurance, right? That's not something that judges know anything about. They're not taught that at law school, right? But members of Congress are supposed to be experts on that, or they hire staff members who are experts. They hold hearings to hear from experts, so on and so forth, right? And so, if they take the time in Congress to pass a law to solve some sort of complex problem, and the court just willy-nilly goes in and was like, well, we think this law is bad and we're going to strike it down. That's going to disrupt things in American society and the American economy, right? Laws are passed to solve very complex problems, and so striking that law down can have huge consequences and negative consequences for life in America. So be careful of that if you're a judge. And so one thing you can try to do to be pragmatic is, if you don't need to strike down all of the law, maybe you can just strike down part of the law. Or maybe you can say a law is unconstitutional not every time it's applied, but only in certain instances where it's applied to certain kinds of people. So if you limit the scope of the decision, right? If you try and avoid a sweeping ruling, if you try and make the outcome of the case very limited so that You don't like you would have to take other cases back to court to figure out similar problems. Any of these approaches make ensure that you're not disrupting things too much by acting too rashly, striking down too much of the law, that sort of thing. And then there's this theory called the process oriented theory of judicial review. This is an interesting kind of take, right? Because it says, actually, it's okay for judges to be aggressive in striking down some kinds of laws, but judges should be more hands off and deferential to Congress when it comes to other kinds of laws. So, how do you draw, where do you draw the line? Well, courts should avoid striking down laws that where judges don't have any expertise, like how to regulate the economy. But if laws are restricting the ability of people to participate in democracy by taking away the right to vote, by limiting who can run for office, by undermining the freedom of speech, right? That's when courts should be aggressive and strike laws down. Why? Well, let's say, the policy of the Republican Party, at least used to be, that the Affordable Care Act should be repealed and replaced with a better health care solution. They didn't have the ability, they didn't have the votes to do it under the Trump administration to repeal or replace. But, let's say that the Affordable Care Act is just a bad law. The solution to it shouldn't be running to the judges to have it struck down as unconstitutional. You should elect Republicans who are running on a policy of trying to get rid of it and just, have Congress pass a new law. Don't let the judges do it for you. But the whole point is, if you are dealing with laws that are attempting to restrict freedom of speech or the right to vote, those laws have the power to exclude people from being able to participate in democracy. We can't interpret the outcome of the election as an endorsement of one policy over another if we are arbitrary in terms of who we let vote. So that's where courts should step in and be aggressive in striking down laws that even sort of come close to impinging democratic participation. Okay, so here's an example of pragmatism. This unfortunately is perhaps Justice O'Connor was too pragmatic in this case because her ruling in Grutter versus Bollinger has just been overturned by the Supreme Court. But at the time, in 2003, she had written that all race-conscious programs must have reasonable durational limits. And so this was an affirmative action case, right? And so she said that if you're going to use affirmative action, you can't use affirmative action forever. You have to reevaluate whether or not it's still necessary to achieve a diverse student body. Maybe you could get rid of affirmative action and still end up with a diverse student body. And if so, that's what you should do, right? And so she's basically, she was willing to uphold the affirmative action policy that was being challenged, but she did so in a way that was very practical, that said, look, there are we perceive problems with affirmative action, and so please just be very, very sure that you absolutely have to use this policy in order to achieve diversity. And if it's a sort of last resort thing, we'll allow it to stand. So she kept her ruling very sort of limited. She wasn't endorsing all kinds of affirmative action in all contexts, but she was willing to sign off on this one particular policy that was being employed at the University of Michigan Law School. And then here's an example of the process-oriented theory of judicial review. So this comes from a case in the 1930s where the court has just sort of swung from being really conservative to much more progressive. And this is also during the New Deal, when the federal government is passing all sorts of new economic regulations than they had ever done before. And so there's a case challenging congressional regulation of milk, and the court upheld the law, right? And then they dropped this footnote in there, and they're like, hey, if we're talking about economic regulations, regulatory legislation that affects commerce, ordinary commercial transactions, that's pretty much almost always going to be constitutional, right? So long as it rests upon some what they call rational basis. If you can go to court and say, look, Congress had this reason for passing this law, and so long as that reason isn't completely crazy, the law is going to be upheld. Why? Again, because Congress has that kind of expertise, judges don't, right? But they say there may be a narrow scope for the operation of the presumption of constitutionality when a law restricts those political processes which can ordinarily be expected to bring about repeal of undesirable legislation. This is a very sort of confusing way for a judge to say something very simple. We are not going to presume that other kinds of laws are perfectly fine. We might presume that they are unconstitutional if they're the kinds of laws that restrict the right to vote or restrict access to freedom of speech, right? Why? Because you need people voting and speaking out to bring about repeal of undesirable legislation around the economy, commercial regulations, right? So you need to protect the integrity of the political process by ensuring you have the most access to the ballot box and most access to ideas via the freedom of speech. And so we're going to make things harder on the government to win. We're going to presume that what the government has done is unconstitutional, and the government has to convince us otherwise. Whereas if it's an economic law, we're going to presume it's just fine so long as some not insane reason, some rational basis is offered. So they set up two very different standards depending on the kind of law. All right, so problems with any of these approaches. One is a sort of loss of legitimacy, right? The adherents of textualism and originalism say, look, when the Constitution was ratified and then each time it was amended, you had basically we the people were agreeing to a set of rules. Just like, if you hire a renovation company to come and like give you a new kitchen, right? You sign a contract outlining a set of rules and expectations, right? If some words in the Constitution seem to be undermined because judges are using one of these other sort of more pragmatic or sociological theories of constitutional interpretation, it seems like you're sort of drifting beyond what the words are saying, what the terms of the contract are, to include something that's, extraneous to that, like, scientific evidence. That's not what we agreed to. We agreed to a set of laws. And so as you sort of stray away from the terms of the contract seems less important. It seems less legitimate. It doesn't seem so much like a constitution. And then there's also a loss of predictability, right? If the text and the history are not the only factors, it becomes harder to predict how courts will rule, right? Even if you're using sociological jurisprudence and you're like, well, okay, we'll let science help identify the correct answer. That's not a guarantee of predictable outcomes either, because what science evolves over time as new studies are done and new things are learned. And so, the law can change just based on evolutions in science. And that makes the law less predictable too. Okay, so if you have looked at the discussion board for this week, you will see that I'm asking you to apply one of these theories of constitutional interpretation to this conundrum. This is a law professor that I follow on Twitter, and he posted apparently what he wanted to do in the month of January was only eat soups or salads. Doesn't seem like a foolproof way to lose weight, but whatever. But he was like a lot of people who try and improve their health in January. Come January 4th, he's already running into trouble. He says that I have made some aggressive classifications of chili and warm ice cream as like soups, right? And so I want to ask you guys and have you debate it in the discussion board. Is this a soup? This particular kind of chili, could it be classified as a soup and under or not, right? And which theory of constitutional interpretation, when you apply it, can you make a compelling argument about whether it meets the criteria for being called a soup? I'm not going to, and here is a bowl of melted ice cream, right? Is this a soup, right? And then finally, we've got a chicken salad in here. Uh, um, and, is this a salad, right? So pick any one of, there are more instructions on what I want in the discussion board section of Blackboard. But I'm sort of opening up the discussion to you guys via the discussion boards. Like, show me like one of the how to solve these very very important classification mysteries by applying something that we've learned. Thank you guys so much. I've hope you've enjoyed this. Again, please pause and use the comment feature to ask questions. I'm happy to answer them. And yeah, I'll see you guys next time.